MSW Media.
Hey, it's Kimberly, host of the Start Me Up podcast. If you like your politics with some loose talk and salty language, you're going to love my show. I interview the coolest people like Mary Trump, Kathy Griffin, and DNC Chair Jamie Harrison. The Start Me Up podcast has an easygoing, casual style and a strong emphasis on left-leaning politics. We also have frank discussions about sex and more than a few spirited rants. Just visit patreon.com/startmeup or wherever you get your podcasts and start listening today.
The rule of law is not just some lawyer's turn of phrase. It is the very foundation of our democracy. The essence of the rule of law is that like cases are treated alike. That there not be one rule for Democrats and another for Republicans, one rule for the powerful, another for the powerless, one rule for the rich, and another for the poor, or different rules depending upon one's race or ethnicity. To serve as Attorney General at this critical time is a calling I am honored and eager to answer.
So now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Hello and welcome to Clean Up on Aisle 45. I'm your host, Allison Gill. With me is Andrew Torrez.
Hey, Allison. So we recorded 75 minutes of a delightful show. And then late in the evening on Monday, as we were sort of bantering and getting ready to say goodbye, the news crossed both of our desks, crossed your desk first. You had the scoop on it, that Politico has received a copy of the draft opinion in Dobbs versus Jackson Women's Health Organization, which is the Supreme Court abortion case. And so by the time you hear this episode, it will be all over social media that this is an Alito opinion, Alito draft majority opinion that explicitly overrules Roe v. Wade and Planned Parenthood versus Casey, holds that there is no constitutional right to an abortion. And we thought, since we record the show early, that we would at least give you a couple of minutes of an instant reaction.
Yeah, and according to Politico, I have no idea how Gerstein and Ward at Politico got a hold of this, because this is the first time court watchers can remember a draft opinion being leaked before a decision.
This never happens. Never, ever, ever, ever. And I can tell you, as somebody who's had friends who are Supreme Court clerks, that they take that very, very seriously. That this is this is not it's not a hoax. It's not. This is very clearly Alito's draft opinion circulated to the justices. My complete spitballing, because we have nothing else to go by but then spitballs right now, would be Clarence and Ginny Thomas leaked this as part of their "yay, we're conservative activists," because they clearly value that more so than norms like the rule of law. I have zero evidence for that. Well, I have the Ginny Thomas sending out, we need Donald Trump to declare martial law in connection with the 1/6 insurrections. So, reasonable suspicion, but no evidence.
So my very, very top line understanding is that this just takes it away. It just overturns Roe and leaves it up to the individual states whether or not they want to ban abortion.
So yes, and can I just, this is not against you personally, but I want to stop that rhetoric, right? Like, Republicans have been using the, let's leave it up to the states. You know what's left up to the states? Things that are not rights, right? So when we say we leave it up to the states, that's like, can you drive 65 on the highways? Right? Can you have a sales tax on cabbage? Right? If something is a fundamental right, the definition of something being a fundamental right is that you do not leave it up to the states. I'm sorry.
No. I totally agree with you. I'm just saying what will happen. I'm just saying what will happen.
Yeah.
So 4 key passages that I'll just read. We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision. That's Alito. Another passage. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. Another passage. The inescapable conclusion is that the right to an abortion is not deeply rooted in the nation's history and tradition. What? Sorry. Try that again. It's hard to read. The inescapable conclusion is that a right to an abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibition of abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973.
So, Section A1 discusses the question of what a right is. And Alito, and if this is to be the majority opinion, is engaged in a radical rewriting of our nation's history. It will now be centered around a jurisprudence of stupid, of the sort that lawyers have been gently correcting right-wing activists who have said idiotic things like, well, it doesn't say abortion in the Constitution, so, right, which, doesn't say a lot of things in the Constitution, because the Constitution lays out general principles, which it's then up for courts to decide how to apply those general principles in terms of governing everyday life. That is about to end. What I'm about to read to you from Section A1 is just rhetoric. It cites almost no cases, and here's Alito's language. The Constitution makes no express reference to a right to obtain an abortion, and therefore those who claim that it protects such a right must show that the right is somehow implicit in the constitutional text. That is not and has never been the test for understanding what is a right in the Constitution, and Alito cites to 0 cases in support of that sentence. Instead, he continues, Roe, however, was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned, and then it quotes Roe. And that privacy right, Roe observed, had been found to spring from no fewer than 5 different constitutional provisions, the 1st, 4th, 5th, 9th, and 14th Amendments, and then cites again to Roe. One of the things that I have tried to sound the alarm against in the right wing's jurisprudence on basic individual rights is the erosion of the right to privacy, which does not mean what we think of as, hey, I'm going to shut the door and mom can't come in the room, right? I want to be private. The Supreme Court's jurisprudence on the right to privacy, dating back to the early 1960s, is a jurisprudence that is grounded in the implicit liberty inherent in the Constitution to engage in the most personal and basic life decisions that are key to an individual life in a free society. Those are decisions about whom to marry, decisions about how and when to engage in personal relationships, sexual intercourse, whether to use birth control. And it is very true that none of these things are mentioned in the Constitution. If this is to be the test, there is absolutely no foundational basis for thinking that the Constitution protects a right to marriage of any sort, let alone gay marriage, that the Constitution protects a right to contraception of any sort, that the Constitution protects a right to marry someone of a different race, that is Loving versus Virginia. Each and every one of those cases, right, are contingent upon the right to privacy that Samuel Alito has just drugged through the mud in his discussion of how stupid Roe is. And if you think that the same right wing that came for abortion is not coming for gay marriage, contraception, and yes, interracial marriage if they get there, then you haven't been paying attention. This is what's on the chopping block. And this is a huge first domino to fall. But this is, on the one hand, I knew it was coming. On the other hand, it is terrifying and heart-wrenching to read.
Yes, it is. All right.
I'm sorry.
No, I don't know why you're sorry. I'm going to need some time to process this. And I'm assuming there's going to be marches. I don't know when the announcement will be. I don't know if the court's going to respond to the fact that they let slip one of their decision drafts, which still blows my mind. But we'll see. We'll see what happens. We just wanted to come on and tell you really briefly about this news before we got into the rest of the show. The rest of the show will be going over the decision on the 1-6 committee's battle in the courts with the RNC and Salesforce, their email vendor, and we're also going to do a little comings and goings. So that is what is coming up as soon as we say goodbye here. But again, Andrew and I saw this news come up and made the decision to record a few minutes about it. By now, I'm sure when this show drops, you will have heard.
Yeah, the show's a happier show, so we kind of felt like we needed to explain why we're yucking it up, and deal with this with some of the gravity that it deserves. So
yeah, because the show you're about to hear was pre Alito's draft being leaked. So that's all. That's why we're here, and we will see you next week. And of course, we're going to go over this on our individual shows on opening arguments. We're going to talk about it on the Beans. So stay tuned for that as well. Thank you very much. And on with the show we recorded just not an hour ago.
So yeah, now it's clean up on aisle 45 time. And for a long while yet, it is going to be clean up on aisle 45.
Hello and welcome to Clean Up on Aisle 45. It's Wednesday, May the 4th be with you. And this is episode number 68 of this podcast. I'm your co-host, Allison Gill. With me, as always, is Andrew Torrez. Hi, Andrew.
Hi, how you doing?
I'm doing well. We've got some big news in court filings today that didn't seem to hit very hard on the mainstream media. I hope you enjoyed my summary.
I did, very much so.
Thank you. So we're going to be going over that. But first, we need to give a shout out to our new patrons. Post-Nut Clarify, Obligatory Firm Offer Joke, Jill Winston, Christina Van Ralty, and My Dog Ate My Patreon Name. Excellent. And if you'd like to join the team, head on over to patreon.com/aisle45pod. Sign up for as little as $1 an episode.
Yeah, and since it's the end of the month, we also give a shout out to our Hall of Famers. These are the ones who support us at the sponsor tier. And, I don't want to say that we love some people more than others, but we definitely love them the most. So big thank you to Tucker Carlson's Bromiopathy. No ducks given this month. That is at Atomic Penguin 7 on Twitter. Mike Hudson, not a namer of dragons. Metacon 7, Lance Buckley, January 20th, baby. Greg Kreimer, dude. David in Brooklyn, that period. I figure it's actually Mr. T's middle name signing up for us, but Patty B, Mitchell, Charles Jones, the delightful Jessica Outbeer, Jameel R. Chohan, Chris Waltrip, Mitchell, and our all-time great Chris Simpson.
Thank you. Thank you so much. And everybody, don't forget, on Friday, May 13th, 3 p.m. Pacific, that makes it 6 p.m. Eastern, we will be having a little Zoom call for our patrons. So head on over again, patreon.com/aisle45pod to sign up. We would love to see you there.
Yeah, and if you're a patron at any level, you can join, have fun with us. It's a lot of fun.
Any level. And ask us questions. ad infinitum. Well,
or just make statements. That's also
yes. Oh, actually, just an hour.
yeah. I like how you have to clarify for our listeners. Ad infinitum means 1 hour.
Yeah, that's literally totally the translation. I'm sure. No, it's not. And now on with the show. All right, so first up, the RNC and Ronna Romney McDaniel versus Pelosi and the rest. And this is, I wrote up a little, this is a long filing, right? This is what, like 60 pages, something like that. And it's a ruling on the arguments that the RNC presented as to why all of the stuff from Salesforce, their email vendor, shouldn't be handed over to the January 6th committee. And we have a filing summary, right? I went through and I kind of broke it down, put it together in as basic terms as I could. And that's what we want to tell you about today is this filing. It's this ruling. It's pretty, it's intense.
Yeah, it continues with the theme of, boy, the 1-6 committee has an awful lot of information from an awful lot of sources. One more thing that I want to point out, right? This lawsuit was filed in the U.S. District Court for the District of Columbia to block subpoenas, right? So RNC filed it against Nancy Pelosi and the House and the 1-6 committee and, probably her puppies and, everybody they could find, right? It got assigned to Judge Timothy J. Kelly, a Trump appointee. And we told you on this show and on my show, right? I have practiced in front of Judge Kelly. I know that he's a Trump appointee. I know that he is conservative. He was nothing but fair in my case. He is a competent, qualified Trump judge. And like, there's a difference, right? Like there was certainly, for most of the Trump presidency, he was appointing, Justins and Corys and 27-year-old Federalist Society members with zero legal experience. That's not what we have here, right? We have somebody, we told you from the outset, right? This is not the fix is in. This is not somebody who is going to put their thumb on the scale for, nepotism and idiocy. And with that in mind, shall we talk about, kind of what this opinion does, and where do you want to start?
Yeah, well, let's go over what it says. Let's just kind of give a brief overview here. And we can talk about why the decisions were made the way they were made after that. But the committee, the 1-6 committee, subpoenaed Salesforce and asked them for data showing how their emails performed between Election Day and January 6th, like how many people opened, how many people clicked through, how many people donated, that kind of stuff. They wanted to know who worked on those emails, composing them, and who worked on them at the RNC, who worked on them, who did they have discussions with about writing and crafting these emails, and who might have more information about these emails. They wanted to know reports. They wanted to see reports and analyses from Salesforce that they conducted about the rallies on 1-5 and 1-6 and internal communications related to those reports. And they wanted to see communications between Salesforce and the RNC and the Trump campaign. Any communications in general. Now, the judge kicks it off, right?
I want to just jump in for a second and say, on page 5, for example, they quote from one of these emails. And just so you understand as a listener the role that Salesforce is filling here, these are fundraising emails. These are the emails that your Aunt Kathy gets that's like, if you don't give $50 to the RNC now, Joe Biden will unleash, an army of pedophile Cerberus again, right? Like, it's so actual email cited in the actual subpoena. We have the capital truth. Capital today will be a historic day in our nation's history. Every single patriot from across the country must step up. Capital right, capital now. If we're going to successfully capital defend, you can see who this is aimed at, the integrity of this election, President Trump is calling on you to bolster our official Defend America Fund. Okay, so yeah, Trump and the RNC were fundraising off of the big lie that the election was stolen, and that was in connection with orchestrating and designing and trying to get people to show up at the Capitol on 1/6. So I just wanted to be clear because, like, we've talked about, how Eastman's emails were, stored on his Chapman University server. This is not, they're not just subpoenaing Salesforce because that's where the emails are, although that's part of it, but also because Salesforce profited, right? They were paid to come up with this bullshit to get people riled up to think that the election was stolen and show up on 1/6. Anyway, sorry.
No, and we already know that there is a grand jury in the U.S. Attorney's Office in D.C., the Department of Justice, that's investigating the same thing that Sidney Powell did with her super PAC and whether or not she defrauded investors or donors when she was using the big lie to raise money for her defense, the Kraken team. So, this is kind of along those same lines. But, did Salesforce write these emails? Did the RNC tell them what to say? Did Trump campaign tell them what to say? How did these come about? We need internal communications, et cetera, et cetera.
Exactly right.
So now the judge says, all of that's cool. You can have all that, except some privileged reports and analyses about the rallies on 1/5 and 1/6, and which are possibly legit covered by attorney-client privilege, work product privilege, just certain privileges, right? But that's a very small component of what the committee is looking for in their subpoena.
Yeah, and procedurally, I think it's important to note that sort of what happened here, right? Which was the subpoena went out from the 1/6 committee to Salesforce, and Salesforce is like, we make money off you grifters. We don't have a dog in this fight. We're 100% going to do everything Congress asks us to do. Because you know why? Like, we're just a business, and that's what people do when we're not, criminally corrupt.
Yeah,
So,
and they have said, we're a little concerned that some of the emails we sent out might have stoked violence on the Capitol.
Yeah, we're
they
used
said
to, the standard political bullshit, but, maybe, this went too far. So the RNC went into court to sue to block Salesforce from complying with the subpoena, right? And that's why this is really significant. And they raised 6 different arguments, which I know you are prepared to dissect at length. But the arguments are, number 1, it violates their free speech First Amendment rights. Number 2, that it violates the Fourth Amendment. That was a fun one. Number 3, the argument, and again, this has a lower winning percentage, a worse batting average than the Kraken's, right? That the subpoena does not advance a valid legislative purpose. They've been trying to hit that one out of the infield since, Trump's only term in office, in arguing that, every congressional investigation into Trump's crimes ever was not a valid legislative purpose. And guess what? That argument is O for the courts.
Yeah, and
it
now
is a 0.
Now it's just a sad bunt that flies off the bat and hits them in their own ball sack. That's all. They can't get it. Not only can they not get it out of the infield.
That is the best running with that analogy.
Thank you. I figured I'd take it to
I
that
love it.
level. And I want to ask
go
you
ahead.
real quick here, because it's going to come into play that there are 2 parties in this suit. There's Salesforce and there's the House 1/6 committee.
Right.
And from my understanding of this, you can't get to the merits of an argument if you don't have jurisdictional standing. And so what the 1/6 committee argues is they have no standing in their lawsuit because of the speech or debate clause. You can't sue Congress. And so this whole thing should go away. But what the judge says is, well, we got to look at the 2 separate parties. Can they be split up? Can the case against Salesforce exist on its own, et cetera? And they've determined. Well, I'll tell you what the judge determined in a little bit, because we do actually get to hear the merits, but not because RNC can sue the 1/6 committee, right? So we do get to hear some of the merits of those arguments, and they're They're fun.
It is. I want to break what you just said into a couple of different components, right? Because you are exactly correct. I want to emphasize raising jurisdictional procedural standing issues, right? It is not, there's nothing inherently wrong about doing that on either side, right? Like, it is a perfectly valid way to tell the court, hey, before you evaluate the substance of this dispute, let us know, right? Like, we think there is a legitimate argument that says this is not a thing that you should decide, right? And what makes something not a thing that you should decide? A bunch of things. But generally they fall into three kinds of buckets, right? The first is when there is the absence of an actual case or controversy, right? And this is sometimes colloquially described as the requirement for standing that says, you know, there must be an actual live controversy between the parties because the court does not issue advisory opinions, right?
Yeah, and we've seen that in other filings.
Yeah, right.
Where they wanted the court to
to
decide something that hadn't happened yet, and the court's like, I don't fucking do that. And they're like, okay.
Right. Yeah, exactly right. So that's a big question on standing. And notice that, right, there's a lot of gray area, right? Like when somebody says, I'm about to punch you, right? Can you go to court and say, look, like they said they were about to punch me, or do you have to wait for them to actually punch you? And, you know, shocker, when someone says, I'm about to punch you, you can go to court and get a judicial determination that if they punch you, that would be a bad thing, right? And that's, you know, that's typically false. I'm oversimplifying a lot here, but that's typically what we think of as declaratory judgment actions, right? Okay, the injury hasn't occurred yet, but it's imminent. It's going to happen. So I do have standing. So, all right, this is not a question about standing. The second category of issues comes up when there is not a justiciable remedy for the thing that you're seeking, right? And this is a more complicated issue of standing. But again, it rests on the idea that your state courts are courts of general jurisdiction, right? If person A has a problem with person B, they can always go to a state court and file a lawsuit. Now, the court may throw it out, may say that doesn't amount to a cognizable harm, but the court won't say, I can't hear your problem, right? The court will say, okay, I can hear your problem, right? So I frown at Allison on our Zoom here. She decides to sue me. She runs out to a district court, a trial court in, let's say, California, where she lives, and sues me. I can't go in and argue lack of standing. I can argue frowning at somebody on Zoom doesn't amount to a cognizable harm, but I can say, you know, that the court gets to adjudicate, right, whether my frowning caused harm to Allison. So because federal courts are not courts of general jurisdiction, they're courts of limited jurisdiction, sometimes there are things that feel like they ought to have a remedy, but the law says, sorry, that's just not justiciable, right? And we've talked about that before. And the third category are areas where there are specifically delineated immunities, right? And that's what we have here, right? Which is on the floor of the Senate, on the floor of the House. The speech and debate clause, it broadly immunizes Congress, members of Congress, for any activity that they undertake in connection with the act of governing the United States. And so the idea that you could sue a committee for issuing a subpoena is something that Judge Kelly was like, right, that's silly. But okay, go ahead. Sorry.
Well, I was going to say, but just in case, the House lawyer said, first of all, speech or debate clause bars the RNC lawsuit, right?
Right.
But just in case, here's our arguments on the merits. And I'm going to put merits in quotes, do air quotes there, so that they say, just in case, for some reason, because we are only one party in this lawsuit, if you have to decide on the merits, here's why the RNC claims fall short on the merits. So the 1-6 committee did argue why the First Amendment was not violated, why the Fourth Amendment was not violated, why they have a legislative purpose, how their rules are set up. They went ahead and made all those arguments in their filing, just in case their first reason to dismiss because of the speech or debate clause didn't pass all the tests.
Yeah, that's right. And again, arguing in the alternative is what lawyers do, right? So there's nothing. I just want to be clear because they lost, and we're going to take great pleasure at how the RNC multiply lost. But there's no. But I want to steel bot the other side a little bit and say there's nothing. Just like there's nothing wrong with the House 1-6 committee moving on the grounds that that there was a lack of standing. There's nothing wrong with the RNC briefing up kind of both the standing question and the merits question, right? To be prepared to kind of fall back. And there's nothing wrong with the judge's opinion, which is basically like, yeah, I'm going to kick everything out on standing against the 1-6 committee. To the extent that leaves ambiguity, I'm also going to rule on the merits. So,
and the court did find that the RNC has subject matter jurisdiction over the RNC's claims against Salesforce,
right?
Because the RNC would suffer an injury. That injury is traceable to Salesforce, and the injury would be redressed if the RNC wins the decision. But if the House is an indispensable party and the action couldn't proceed against Salesforce alone, the entire thing has to be dismissed. And the RNC would need to establish Salesforce as a state actor to proceed on the merits. And according to the judge, the judge is like, the court's just going to assume that and go forward with your merits arguments. But before we get to that, the judge does dismiss wholly the RNC's claims against the House under the speech or debate clause.
Right. And I'm not sure that matters, right? Like you often see this in litigation, right? Like at the end of the day, what the RNC wants is to block Salesforce from turning over those emails, right? And so losing procedurally on maintaining claims against the 1-6 committee is a paper loss, right? Like that doesn't potentially deprive them of the remedy that they seek. Now, the rest of the opinion deprives them of the remedy that they seek. But, I would do this all the time, right? Like it where you might sue one party. I'm trying to think of a real world example where this happened. Well, this has happened over the production. I've had to file a lawsuit where a party wants to produce certain cell phone records, right? And many cell phone companies have a policy that says, if you issue a subpoena pursuant to a valid lawsuit, we will turn over those records. If you don't have an existing lawsuit, we're not going to turn them over voluntarily, right? Like that's their dividing line on respecting their clients versus complying with the law. So sometimes you will say, you will bring a lawsuit where the purpose is to have a lawsuit open in order to produce those AT&T records or, whatever the cell phone provider is. And you don't really care about the claims against the other side. I've also had insurance lawsuits, right, where you anticipate, right, you begin as a claimant against the insurance company and all the other co-claimants, right, in connection with, a big pollution spill, right? And you would say, we're going to sue everybody that was involved in this, mass public health hazard. We expect that the parties will realign, right? That the interests of those who were covered by insurance will all migrate their way over to the plaintiff's side of the V. And that happens all the time. So, so parties can be, can be fungible in lawsuits. So
got it. Now, the RNC did argue against using the speech or debate clause to dismiss this case. They argued speech or debate doesn't apply because they said there's no legitimate legislative purpose. And the judge said that fails because Salesforce and the Select Committee narrowed the scope to very specific things. And the RNC also argued the subpoena is overbroad, but again, the House's scope is narrow, and the speech or debate clause prohibits the court from parsing the demands so finely, and they cite the case law for that. The RNC also argued the subpoena is politically motivated, and the court says, I don't give a shit. That's possible, but the court can't examine motives when evaluating whether the speech or debate clause applies, and you should know that if you fucking went to any law school. Also, I'm paraphrasing. Also, the RNC...
but only lightly.
And then the RNC says the court can't rule on the speech or debate clause until it addresses the merits of the congressional authorization claim. And apparently the RNC doesn't understand the order of judicial operations. He said that the judge says, this has intuitive appeal. It feels like a great argument, but precedent forecloses it.
I really, as a lawyer, when I read that one, like that felt like the bless your heart of. It was like
cool.
Because if I'd been on the opposite side of that ruling, I would be like, oh, well, that hurts. You're saying, I get why, an idiot might think this, but if you had done your job and read the cases, you would know that that's not the case. Wow, that
was good. But the court makes the right call. They say, look, I'm not going to look at the merits on the House side of the issue on the speech or debate clause. That is outright dismissed, and one of your things is moot anyway. So what I am going to look at on the merits is the Salesforce side, because there could be injury, it's traceable to Salesforce, and that the injury would be redressed if the RNC won. So the court's like, and I didn't quite get this, and maybe you can explain it to me, but the judge is like, all right, look, I'm going to just assume that the House is not an indispensable party and that Salesforce is, quote unquote, a state actor, so we could proceed to the merits. But he didn't really explain how Salesforce is a state actor or why the parties are not indispensable.
Yeah, I think that's correct in reading it. And again, it doesn't surprise me, right? Because if you're thinking about, right, as a trial court judge,
appeals,
you're always your question is going to be, what is the appellate court going to do with my opinion? And by writing it this way, right, Judge Kelly
addressing these merits, even if you might not have to, it prevents it being kicked back down to his court to make those merits decisions.
Well, Judge Kelly has given the appellate court a couple of different outs to say, so for example, suppose he doesn't, as far as I can tell, but suppose the appellate court is convinced that he's gotten the law wrong on one of these 6 main issues that we're going to talk about later on, right? Like, an appellate court now could look at this and go, yeah, we're not sure that we buy the First Amendment analysis of the district court's opinion, but that error was harmless because the district court passed lightly over this standing issue, and we find, as the appellate court, because although you review the facts to determine whether they're clearly erroneous, you review conclusions of law de novo, right? So the appellate court could very easily say, yeah, no, we find that as a matter of law, the 1-6 committee is an indispensable party, and therefore there's no jurisdiction over this entire thing. So therefore, that constitutes harmless error, and we're going to deny your appeal. Right?
Gotcha.
If you do it the other way around.
Yeah, but now you have that on your plate in case they agree that they're not indispensable, or that that they do have to be decided on the merits, and so then they've got the whole merits argument laid out for them if that's the way they want to if they need that to decide on the appeal.
That's exactly right.
Okay, that's cool. Covering your bases.
Yep.
Got it. For a Trump-appointed judge, not bad. All right, so let's get into just a couple of things here. The court reminds everyone of the legal standards. The court says they have to dismiss an action if it lacks subject matter jurisdiction. They must. And they must grant summary judgment if there's no genuine dispute as to any material fact, and if the movant, which is the House at this point, is entitled to a judgment as a matter of law. So they just wanted to remind everybody of that. And then they get into that analysis we went over about the RNC arguing the speech and debate clause and the subpoena and why none of that works. And then we get into the merits of the case. First, the court must presume the House has a legitimate legislative purpose, and the House doesn't need to declare in advance what they might do when they're done. So, if the RNC, which they did ask, is like, well, what's their purpose? And it's like, they don't know yet. They might not know yet, and I can't tell you, and the court can't determine that anyway, because then you're weaving into, separation of power stuff. Second,
I think that's right, and I should add that the court kind of analyzes these in a slightly different order. So they start on page 30, and it might be worth us kind of hitting that first with the argument that we have seen. Eastman made it. A bunch of these morons have made this argument that the select committee is not even a real committee. What is it? It's not properly authorized because, the hand-picked trolls that Kevin McCarthy wanted to serve on the committee aren't serving on the committee, so therefore it's not a real thing.
Right. And the court says, hey, I can't tell the House of Representatives what its own rules require. Because that would be violating the rulemaking clause in Article 1 of the Constitution. I can't go against the Constitution. Sorry.
Yep. No, that's exactly right. And that is based on the technical argument. Because to be honest, the argument that the committee shall have 13 members is a slightly stronger one than the one that says it must also have the trolls that, Kevin McCarthy wanted to appoint on it. And the court has to parse those a little separately, right? Like, because there is, to borrow Judge Kelly's words, some intuitive appeal to the idea that, the enabling legislation says shall have 13 members. What are you doing with only 11 members, right? Well, the answer is you guys sent us morons that are not appropriate. We sent them back and said, try again. And Kevin McCarthy said, I'm going to take my ball and go home. And so,
and the court said they can't rule on the House rules, right? That's
exactly right. That's the separation of powers issue. With respect to the consultation requirement, right? The court said, look, all we can do is evaluate whether Pelosi talked to McCarthy, and the record shows that she did. That's what consult means. So, so get out of here with this.
Yeah. And the court also says that the House can seek info that might have an indirect bearing on the subject that they're looking at, because investigations branch off and go in different directions.
Yep. And that's, I'm sorry.
Oh, I was just saying, that's a very important point here. Like, even if I could tell the House what rules it should and shouldn't have, and if they followed them, their investigative power is very broad. And so they can't really, it's like you can't, the court can't parse this stuff for you. Sorry.
Yeah. And this begins on page 33. This is where we're bleeding over into the second argument of, is this, okay, we've now said, all right, the 1-6 committee is a valid committee. Does it have a valid legislative purpose in issuing the subpoena? Right. And the RNC's arguments are the same grab bag of terrible arguments before. Like, this is politically motivated. This is ad hoc law enforcement. You're not really trying to pass legislation. And again, the court, I think, does a very nice job here of saying, it's not the job of the court to try and second guess what the legislature would do.
It's not even the legislature's job to decide what it would do at the end of an investigation that's not done.
Yeah, because this is how legislation gets made, right? Like, you say there was ideally, this is how legislation gets made. You say there was a problem, right? What's the problem? armed insurrectionists came to the Capitol, breached the Capitol, stormed onto the floor of the Senate, and disrupted one of the most important functions of the Senate. Okay. So what do we want to do? We want to find out how the hell that happened to make sure that never fucking happens again. Right. And the idea, right? Like, I don't know how you could go into oral argument with that as the backstop and make an argument, right? Like, if a judge were to look at me and say, Mr. Torrez, are you honestly contending that there is no valid legislative purpose unless you specifically define in advance what you want the law to be before you've gathered the information necessary to determine whether that law is necessary? Is that what you're arguing before this court, Mr. Torrez? I would have to say, we withdraw the point.
Never mind. Never
yeah.
mind.
Yeah, of course, never mind.
Yeah. And also what the judge says here is that the subpoena, in order to be invalid, would have to be solely for a prohibited purpose under the law, right? And which this is not.
Yeah. That's the I can hate you for two reasons argument.
Got it. All right. So with all that in mind, here's what the court finds on the merits with regards to the RNC's 6 arguments. Their argument that it violates the First Amendment, the court says the subpoena does not violate the First Amendment. That it violates, and we'll go over these a little bit if you want to talk about them, but if the idea that it violates the Fourth Amendment, the court says the subpoena does not violate the Fourth Amendment. Well, the subpoena, it has no legislative purpose. The court says the subpoena has a valid legislative purpose. And then the RNC says, no, but the committee doesn't have congressional authorization to issue a subpoena. The court says the committee is properly authorized. But the subpoena is excessively broad. No, the subpoena is not overly broad or unduly burdensome. Sorry. And finally, the subpoena violates the Stored Communications Act. And this one's fun. The court says the Stored Communications Act claim is moot because the House confirmed it's not seeking communications covered by the Stored Communications Act. So, moot.
Yeah. So I correct summary on all of it. I want to back up because the Stored Communications Act, the way in which the 1-6 committee avoided this argument was by telling Salesforce, hey, don't give us anything that violates the Stored Communications Act. And Salesforce confirmed to the court, okay, we're not going to do that. And so there's nothing else to do there at that point, right? That is classic negotiations and discovery. And let me give you, and this is a direct analogy that in fact comes up in my cases all the time. If I am subpoenaing records from a doctor's office, for example, one of the very first thing the doctor's office will say is, I'm not going to give you records that violate HIPAA, right? If it would violate any patient's right to confidentiality in the maintenance of their records, unless you have a waiver from that patient, I'm not going to give you the record. And I'll have a waiver for the patient that relates to the particular litigation. And then they'll say, but sometimes other patients' information winds up in a patient's file for, whatever reason, right? And when we say for whatever reason, I don't want to say usually, I want to say in my case, it came up because of mandatory reporting for sexually transmitted diseases, right? And what I was able to tell the doctor's office was, yeah, fine. We don't want the other patient's stuff. We want the patient's stuff for which we have the waiver. And they said, okay. And their answers would say, we are producing all the documents that are responsive, that are within our possession, custody, or control that do not violate the HIPAA Act of 1990, whatever.
Yeah, no, just redact what they can't hand over.
Yep. Exactly right. Still working backwards. The overly broad, unduly burdensome, those are boilerplate objections, right?
But it's just so dumb because the I think in an amended supplemental briefing, the House got together with Salesforce and said, okay, we don't want any of your donor information. We don't want any of this. We just specifically want this. We specifically want that. They narrowed the scope of everything they wanted and then, put that in there. So this is all we want because the right wing, talking head machine and the anger mangle, which is the Ingram angle, went on TV and said, they want all of the voter information and emails and your blood type and your DNA, and the fucking committee's like, nah, dude, we don't want any of that. Here's exactly what we want, and this is it. These are the four corners of what we want. Thank you very much. And so I guess they just didn't want to take out that argument in case, I don't know, Hail Mary.
You always want to give the judge sort of every available out. So, again, I don't fault the way this was, that these particular arguments were litigated in the alternative. I'm just saying they're not good arguments. The Fourth Amendment argument was weird to me.
Tell us about it.
Yeah. So, right, you have a Fourth Amendment right against self-incrimination, right? And that was the gravamen of what the RNC was arguing, was saying, because this is so overbroad and exceeds any lawfully authorized purpose, it effectively constitutes an unreasonable search and seizure, right? It means that you were doing so without probable cause, without adequate justification for undertaking the search in the first place. And if you're sitting there thinking, that seems to be a kind of a, round peg, square hole kind of thing, you'd be 100% correct, right? Like there are almost no federal cases that have applied the Fourth Amendment in this way. And in what the opinion calls one of the few federal cases on point, it went the other way, right? So it was a case called McFall. And in that case, the House committee issued a subpoena to the executive secretary of the Civil Rights Congress. And that subpoena demanded production of all records, correspondence, memoranda pertaining to the organization of the affiliation with other organizations. They meant communists, right? And all monies received or expended by the Civil Rights Congress. And the Civil Rights Congress was like, well, this seems like a fishing expedition designed to, tar us as communists. So we think it is, quote, so broad as to constitute an unreasonable search and seizure in violation of the Fourth Amendment. They lost at the Supreme Court, right? The Supreme Court was like, yeah, this is a close call. This is a broad subpoena, but the permissible scope of materials that could reasonably be sought was necessarily equally broad. And so it was not so broad as to violate the Fourth Amendment. And here Judge Kelly says, so too here.
Just like that.
Yeah, and that's really what it means. It is saying, not my place to say for the first time in American history that a congressional subpoena is so obviously broad on its face as to constitute a violation of the Fourth Amendment.
Yeah,
I'm not going to be the first person to carve that one out.
No, and
that's above my pay grade.
They're asking for a lot because you commit a lot of crimes.
Right.
maybe your insurrections shouldn't be overly broad.
Yep.
Then
and notice also, I've defended, if not praised, the argument in the alternative. I will tell you, it is bad. Like, good argument in the alternative is where there are completely disparate universes of fact that can justify each of those arguments, right? And the best way to figure out what that is by looking at what this isn't, right? So notice that, like, their Fourth Amendment claim requires you to be sort of on board with both the idea that it's super broad, which the court's not on board with, and the idea that it lacks a legitimate legislative purpose, which the court is not on board with. So it winds up really not being much of an argument in the alternative, because once the court says this has a valid legislative purpose and it's not super broad, those pre-existing assumptions are now called into question. So
makes sense.
Yep.
So also, okay, so the conclusion here for all these reasons. The judge said, the court will dismiss all the claims against House defendants, dismiss as moot that Stored Communications Act claim against Salesforce, enter judgment against the RNC on the rest of its claims against Salesforce, and enter an administrative injunction to give the RNC time to seek an injunction pending appeal. And the reason that the court did that is because all of this shit was due May 2nd, which is when this ruling came down. It didn't leave a lot of time for the RNC to appeal. So the court said, you know what, we'll give you a couple days. We'll give you till May 5th
right. Yeah. Tomorrow.
to file your appeal. And I'm sure they will.
Yep.
I'm sure they will. So my questions become, first of all, I want to ask about the appeal and the timeline of that appeal. I'm assuming if I were the House, I would probably file for an amended expedited schedule for deciding based on the timeliness, the importance, and the fact that the Congress has an expiration date, which they've argued in other filings too. Like, hey, the time is of the essence here, the court. But I want to talk about that. But my first question is my instant thought went to all of the other lawsuits out there right now from recalcitrant Republican witnesses saying that the committee is illegitimate, they can't have my phone records, they can't have my subpoenas, I'm suing you, etc., and all of their arguments about the legitimacy of the panel. But I think we've already had some court decisions, multiple in fact, that say that there's a legitimate legislative purpose and that the committee is So I don't know if this impacts other cases. Maybe it just adds. Maybe, I guess in all those other cases, we might get a supplemental filing from the good guys saying, hey, here's another judge who says that the committee is legitimate. But in like the Meadows case, for example, he argues that there's OLC memos that prevent him from having to show up for a subpoena. So I don't know that this covers that necessarily. But what are your thoughts on how this decision, because it is a big one, how does this impact other lawsuits that are out there and open and pending right now?
That is a fantastic question, and I'm going to parse it into a couple of different components. The first is you asked one of the favorite questions of Civ Pro law geeks like me everywhere, which is a question about res judicata and collateral estoppel. We are already 45 minutes into the show, so I cannot begin to explain that other than to say that one court's ruling on a particular issue of fact is not always binding against another party contesting that same issue of fact. In order to be binding, it has to meet various criteria. And one of the criteria for res judicata is that the parties have to be the same or in privity, right? Collateral estoppel is broader, but this is an area that says what we want is we want to make this balance. We don't want to permit a party or somebody related to a party to take multiple bites at the same apple, right? Once you argue in court there's no valid legislative subpoena and you get a final decision on the merits, we don't want you to be able to go to court and make that same stupid ass argument again, right? We saw this with the Kraken team, right? Like they raised the same dumb argument in the same dumb proceedings over and over and over and over and over and over and over again.
Right. And you'll notice in this ruling, a lot of the case citations are the Mazars case.
Yep. Because that's similar. So, and that gets into it. So the first prong is we don't want you as an individual party to be able to litigate one question over and over and over again. We want the court's ruling to be final. On the other hand, we don't want to stick somebody with an adverse ruling in a case that they weren't a part of, right? Because they might look at it and go, yeah, they lost in that case because the lawyer representing the other side was Alina Habba, and she can barely count to 12, right? Like I would have argued it differently. So the way in which you strike that balance is, I think that I don't know that any of these decisions are going to collaterally stop any of the parties from continuing to raise the argument. But as in this ruling, and you will see this on appeal, you will see the overwhelming weight, the overwhelming number of courts that have considered this question, right, or the unanimity of courts considering this question have determined that the subpoena, that the 1-6 committee in fact has a legitimate legislative purpose. And where that comes into play that's a little different from the Mazars case is remember that appealing does not automatically stay the court's judgment, right? You pointed out this court stayed its injunction for 4 days, right? Because this came in on a Sunday, the records were due on Monday, and the court, very magnanimously was like, all right, RNC, your lawyers get 3 days to kind of work this through and figure out if you want to appeal. And we don't want, if this goes into effect, then your appeal is kind of mooted, right? Let's be honest with you. So we want to give you the right to be able to raise that appeal.
But they also have to ask for an injunction, a continued injunction. They
that is exactly right.
Because they can appeal, but the stuff goes over on May 5th unless a court stops it. And so a court presumably wouldn't be able to make a decision on the appeal in a day. So you have to say, and please, emergency administrative injunction. And I think they can even ask the Supreme Court for that. And I think it's a Scottish judge who gets to decide whether or not that stay happens in this DC. This is the DC Circuit Court of Appeals?
Yeah. So, this is DDC. So it would go to the DC Circuit and then from there to the Supreme Court. This is how things get on the shadow docket, right? This is the very definition of that. Are you going to grant a stay of injunctive relief pending appeal? Now, in the Mazars case, the courts granted that stay all the way up, right? And part of that was based on the idea that you can't put the genie back in the bottle when you're talking about turning records over to Congress. And this is the second half, there is an interest, right, as an individual in maintaining the secrecy of your tax records.
Yeah, and in fact, this judge did determine that there, particularly, and I should say not with the House, but with the Salesforce, that there could be an injury. It is traceable, and it would be redressed if they won on their claims.
Yep.
So I would imagine that the appeals court would grant a stay.
So
here.
So the appellate court, right, again, is going to look at and there are four factors, but it really, the test breaks down into the following three criteria. The first is there irreparable injury to the party seeking the stay, right? And my point on distinguishing this from Mazars is just that injury is somewhat less here, right? Because there was presumed to be an inherent injury in disclosing your taxes, right? Like, my taxes are secret. Nobody gets to see those. And it hurts me if somebody were to take my taxes and leak them out there, right? Here, you don't have that same issue, right? Like, nobody is claiming that the Salesforce data has some kind of inherent value in terms of not being disclosed. Now, the rest of it, right? I think there is still the strong argument of irreversibility, right? That, yeah, once you turn these over to the 1/6 committee, you can't order them to unsee them, right? And that's typically what we think of as a strong component of irreparable harm. The second issue is the likelihood of success on the merits, right? And again, kind of a sliding scale here, right? The more irreparable the harm, the less likely you have to be to win on the merits. But I could very easily see the DC Circuit saying, you got your ass kicked on the merits.
There's no merits here, but perhaps the injury would outweigh that. I mean, because don't they have different weights and stuff, right?
It does, right? That is correct. But there is a point below which the court will say, this, you're going to lose, so we're not granting an injunction to let you lose. And then the third is sort of the balance of the equities, right? And again, this gets drawn out into multiple subfactors, but basically, are we better off waiting and not giving this data to the 1/6 Commission, or running the risk of being wrong, or are we better off delaying and adjudicating the rights properly? And here again, what I just want to do is I think it is likely that the court will probably at least stay for through initial briefing at the D.C. Circuit. But there are reasons to think that maybe they won't, right? That make this a little bit different than the Mazars case, where you at least had plausible arguments going all the way up. And you know what the Supreme Court does? Yeah.
Can they maybe do an emergency administrative stay while they decide whether or not they're even going to hear it?
They certainly could do
because for me, it seems like, with this particular ruling being so thorough, I might say, all right, we're going to give you a week. We're going to take a week to decide if we're even going to hear it. And then come back 4 days later and say, we're not even hearing this. So the lower court ruling stands.
And let me be clear. That is because we just migrated without kind of flagging for the listeners. That is at the Supreme Court, right? The D.C. Circuit has to hear this appeal.
Okay, that's my question.
They have an appeal as of right to the D.C. Circuit. But if the D.C. Circuit says, yeah, we're going to take this up and, no, we're not going to enjoin the district court's ruling pending appeal, then Trump's team, the RNC, will immediately appeal on the Supreme Court shadow docket. Right.
So could the House say, hey, we file this motion to oppose an emergency injunction pending the appeal at the appellate court level, based on the fact that these documents will not be released to the public. They will be released to the committee, and they have some sort of presumed right of privacy, and maybe make that argument as to why end time is of the essence, and we have a legislative need or whatever. And so that's why you shouldn't grant an injunction pending appeal.
They will 100% make all of those arguments,
yes.
right? Because those arguments go to the question of irreparable harm and the question of the balance of the equities. I will tell you, there is a Supreme Court case that basically says, I was alluding to before, once you give something over to Congress, you can't get it back.
And Congress leaks like a sieve.
Right, and it basically says that, right? Mm-hmm. And we need to be honest when we are discussing, these issues, because, that's that's the hallmark of our side, at least. So
now, could the Supreme Court, with the Howler monkey contingent, shadow docket this, run out the clock, say we're not going to hear it until next spring, and then it's a moot anyway because the Congress is over?
100% they could do that. And the only thing that I would say with respect to that, I guess I would say two things. Number one, this Supreme Court, while it is right-wing interventionist, it does not appear to have what I would call true-believing Trump loyalists on it, beyond, obviously, Clarence Thomas, right? And so when an issue has come up that feels like it will only benefit Donald Trump, and it does not tie into a larger conservative cause, the Supreme Court, right? So, for example, right, the executive privilege records, the Supreme Court 8-1 said, yep, guess what? The incumbent president gets to determine executive privilege. The archives will turn over those docs. Are they going to embarrass the shit out of Donald Trump? You betcha. Right?
Now, what happens if they get the appeal, goes to the Supreme Court, and the Supreme Court grants an emergency stay for another couple weeks and then decides that they aren't going to grant cert?
Then that would dissolve. So the terms of the injunction would last until the Supreme Court disposes of the case. And if they say, yeah, we're not going to take this case, then that's it. It's over.
Okay. Because that's what I think might happen.
There are a large number of possibilities there, but I think if you were viewing this as ordinary litigation, and with, today's Republican Party, nothing is, the idea that courts would err on the side administratively of allowing a party to seek all of their judicial remedies is a principle that, ordinarily we would all get behind.
Yeah. Okay.
So.
I got it. Yep. All right. Well, we are going to take a quick break at the 57-minute. We had a 57-minute A block, ladies and gentlemen.
Well,
we're going to take a quick break. I promised everybody we would go over it in detail, so we did that.
This was a lot of fun.
So we'll be right back with some comings and goings and some interesting things happening in that arena right after this break. Stay with us.
Hi there, Diana Erickson here, host of the podcast One Sweet Dream, which is a podcast that shines new light on the Beatles, illuminating their story in ways not seen before. This podcast does deep storytelling to get to radical new ideas and insights that transform our understanding of their story. We've always known the Beatles story was exciting and epic, but there is an even bigger, better, sexier, and more beautiful story that's been hiding in plain sight. And that's what I want to share with you. Historians say that it takes about 50 years to tell the story of an event properly. And so here we are, a little over 50 years later, and have I got a great story to tell. So I hope you'll join us at One Sweet Dream Podcast, where we explore the dream that was and is the Beatles. Episodes will be released every Tuesday and Friday, so please subscribe to One Sweet Dream wherever you listen to podcasts.
And welcome back. This is our other cleanup and comings and goings. And I just want to remind everyone, it is May the 4th. With the calendar turning over to May, the grand jury has now been impaneled in Fulton County. So everything we've been waiting for with connection to what again, to me, seemed like very, very obvious crimes. I know we've continued to discuss is Donald Trump ever going to be held accountable? And, if you're starting your stopwatches, you can click the on button right now. But that grand jury is being convened, and I will remain optimistic until I have reasons not to be.
Yes, and she has said charging decision possibly by the end of the year. And we'll see. We'll see what happens. But I know they're looking at Rudy Giuliani. They're looking at Lindsey Graham and his phone call. Mm-hmm. Of course, and what I want to know about BJ Pak, who resigned mysteriously.
That was such a strange story.
As a U.S. attorney. Then, of course, Raffensperger. These are all people who said they'll come in and talk, but only with a subpoena. And she couldn't get a subpoena without seating this special grand jury because it's different. Yep. The rules are different in Georgia. And so now she has it. They got 23 and 3 alternates, and they've closed down all the streets around the courthouse. And she's got some chutzpah. I'm very excited to see what happens with this investigation.
I am too. I'm crossing my fingers.
All right, and something happened in France recently. Can you?
Yeah, way to rain on that parade. So, if you didn't see this, and we were going to talk about this briefly last week when we went 2 or 3 hours. Far right lunatic and National Rally Party candidate Marine Le Pen got 41.5% of the vote in the second round in the runoff. In the French elections. Yes, Macron was reelected. Yes, the polls were, looking bad at the time. But this is a candidate that got crushed 2-1, 66-34 the last time she ran. So she basically halved that margin, right? Like tens of millions of people said, yeah, that's okay. I'm on board with far right fascist, populism. And there's been a lot of discussion of, sort of, did that movement kind of peak with Trump in Europe and Brexit? And was it an instant in time? And a lot of people are drawing positive messages out of that. To me, that the French election is a giant, yellow warning symbol that says, think again if you think that fascism has been discredited abroad. So
wow, France gets things late. So I think they're still into Alf.
There go all our French listeners.
I'm just kidding. I was actually talking about Germany. No, because when I was there in 1989,
David Hasselhoff.
I was there in 1989, and I'm like, why is everything David Hasselhoff and Alf right now? This is so 4 years ago. Anyway. That's
good shout out to Norm Macdonald, who sounds exactly like Thomas Smith.
But yeah, no, that fascist creep is real. And autocracy is easier than democracy. And and the gridlock in Washington, they're trying to make you fed up with it.
Yep.
That's the job of fascists, is to make you hate the fact that there's gridlock and that it's hard to get anything done in a democracy. Now, I'm not saying don't hate the filibuster. Come on. I'm not saying that at all, because that isn't part of what I consider to be democracy. But if just be cognizant that they're trying to make you sick and tired and apathetic and throw your hands up in the air and not care anymore. That's the whole point of autocracy.
Yep, that is exactly right, and that is the game plan. And it's why we devote a segment at the end of this show to the nuts and bolts of the hard work of moving things along one step at a time. So I think, AJ, you've got a couple of comings and goings for us.
I do. Our POTUS has announced his intention to nominate veteran U.S. diplomat Bridget A. Brink to serve as the ambassador extraordinary and plenipotentiary to Ukraine, an extremely crucial and important role that hasn't been filled since Masha Yovanovitch was canned in a smear campaign by Rudy Giuliani and the Three Amigos.
Yeah.
Cindy Dyer is the nominee for director of the Office to Monitor and Combat Trafficking, with the rank of ambassador at large. Michael Gonzalez, nominee for ambassador extraordinary and plenipotentiary to the Republic of Zambia. Very cool. Michael Ratney, ambassador to the Kingdom of Saudi Arabia. Another very important post. Jeffrey Piat, nominee for Assistant Secretary of State of Energy Resources, and that's different from the Piat who didn't send the National Guard during the Capitol attack.
Yeah, they spell their names differently.
Yeah, Piat. Okay.
Yeah.
And 5 new U.S. attorneys. Ooh. Rachel Crow,
I love these.
United States Attorney nominee for Southern District of Illinois. She has served as a state senator for Illinois' 56th district since 2019, so welcome, Rachel Crow. Joshua D. Hurwitz, U.S. Attorney nominee for District of Idaho. They only have one. Joshua D. Hurwitz has served as an assistant U.S. state attorney in the United States Attorney's Office for the District of Idaho since 2012, so career prosecutor. Mr. Hurwitz was previously an associate at Covington & Burling, LLP, from 2011 to 2012. I don't know anything about Covington & Burling. Do you know? Have you ever heard of them?
Yeah, no, that was after I left. So sadly, Mr. Hurwitz and I did not cross paths at Covington and Burlington Coat Factory.
Who else do we have coming on board?
Yeah, we have Gerald Karam, who is the U.S. Attorney nominee for the Middle District of Pennsylvania. He is a criminal defense attorney in private practice in Pennsylvania right now. Jacqueline Romero, she is a U.S. Attorney nominee for the Eastern District of Pennsylvania, and she has been an AUSA in that office for the past 15 years, so since 2006.
About time.
Yeah, right. And Philip Talbert, who is the U.S. Attorney nominee for the Eastern District of California. And he was appointed by the Attorney General as U.S. Attorney for the Eastern District of California since December 2021. So that was an interim recess appointment, and now will come up for a nomination that requires the advice and consent of the Senate to take over as a full-fledged U.S. Attorney with the confirmation of the Senate. So welcome aboard.
Welcome to everyone. And, it's kind of a bummer that it's taken over a year to get some of these U.S. attorneys seated.
Yeah. But welcome aboard. And again, it highlights the point that, you tied in with the French elections, right? Like we know even before their slip into fascism, right? This is sort of inevitable, right? The Republican strategy has been to complain government doesn't work. And then when they get the levers of power, break them. And it is super easy to make government not work. It is super hard to make it work. And so if you're not grading on a curve, you're not thinking about the strategy the other side is employing.
And I would like to send a little welcome out to a guy named Wyndham, who comes from, I think, Delaware, who's been brought into the U.S. Attorney's Office to run the second grand jury in charge of the heavy conspiratorial cases and crimes of the January 6th attack, and of course the stuff leading up to January 6th. He's going to have a whole team of lawyers working on that stuff, and so now we have 2 grand juries in D.C. investigating January 6th. One is investigating the boots on the ground stuff, and the other is investigating the conspiracies and higher, like the seditious conspiracy, Oath Keepers and stuff like that, up to the tippy top. So welcome to that guy. May Godspeed be with you, or whatever.
May God have mercy on your soul.
And that, quite a big job. Anyway, thanks to everyone. Thanks to our new patrons. We're going to see you on the Friday the 13th, but we'll see you for, I think, another episode before then. And anything else you want to leave with, Andrew? Any other final thoughts?
No, other than thank you again to all of our patrons and everybody that supports the show. We appreciate it. We love being able to do this show, and thank you, all of you who make that possible.
Yes, it is because of you that we can do it. So thank you, and we'll see you next week. I've been Allison Gill.
I'm Andrew Torrez.
This is Cleanup on Aisle 45. Cleanup on Aisle 45 is written, researched, and produced by Allison Gill and Andrew Torrez, with editing by Molly Hockey. Our art and logo design are by Joelle Reeder and Moxie Design Studios, and our music is composed and performed by Adam Orr. Cleanup on Aisle 45 is a proud member of the MSW Media Network, a collection of creator-owned podcasts dedicated to news, politics, and justice. For more information, visit mswmedia.com.
Season 4 of How We Win is here.
For the past 4 years, we've been making history in critical elections all over the country. And last year, we made history again by expanding our majority in the Senate, beating election-denying Republicans in crucial state house races, and fighting back a non-existent red wave.
But the MAGA Republicans who plotted and pardoned the attempted overthrow of our government now control the House, thanks to gerrymandered maps and repressive anti-voter laws. And the chaotic spectacle we've already seen shows us just how far they will go to seize power, dismantle our government, and take away our freedoms.
So, the official podcast of the Persistence is back with Season 4. There's so much more important work ahead of us to fight for equity, justice, and our very democracy itself. We'll take you behind the lines and inside the rooms where it happens with strategy and inspiration from progressive changemakers all over the country.
And we'll dig deep into the weekly news that matters most and what you can do about it with messaging and communications expert, co-founder of Way to Win, and our new co-host, Jennifer Fernandez-Ancona.
So join Steve and I every Wednesday for your weekly dose of inspiration, action, and hope.
I'm Steve Pearson.
And I'm Jennifer Fernandez-Ancona.
And this is How We Win.